Okay, we're talking about civil liberties and public policy today. So what are civil liberties? Um, well, they're contained in the Bill of Rights. Um, so the First Amendment, right to freedom of speech, religion, assembly, petition, right to bear arms, courting of soldiers, the Third Amendment, searches and seizures, grand juries, Article 5, um, due process of law from the federal government, right against self-incrimination, Sixth Amendment, right to impartial jury, um, trial by jury in common law cases for Amendment 7, um, Eighth Amendment, cruel and unusual punishment, Ninth Amendment, the people retain all rights um, not stated in the Constitution. Um, so the enumeration of the Constitution of rights shall not be denied others retained by the people. So even though we don't state them all in the Constitution, the people retain the other ones. Then the 10th Amendment, the same kind of thing um, for the states. Excuse me. Civil liberties. Legal constitutional protections against the government. So these are protections that each citizen enjoys against the government. Bill of Rights in the states. The Bill of Rights, as we just looked at, first 10 amendments to the Constitution, and they are focused on the national government. Remember, that was part of the deal between the Federalists and the Anti-Federalists. The Anti-Federalists would support the Constitution if those 10 amendments were added. So they were added as part of that deal. And then state constitutions, then through the doctrine of incorporation, the Supreme Court has then incorporated them into state and local laws. The Bill of Rights applied to the federal government, but initially not to the states. Following the Civil War, the 14th Amendment guaranteed due process in the states. So the first 10 amendments, you might think, well, it's all the same. It's the federal government, it's the states. And actually, the first 10 amendments just applied to the federal government. The 14th Amendment, which was due process in the states, then applied all those same constitutional protections to the state. And each aspect of the Bill of Rights through the 14th Amendment after the passage in the Civil War was gradually adopted um, by the Supreme Court. So, for instance, the Fourth Amendment protections didn't apply to the states, but as the 14th Amendment was passed after the Civil War, the Supreme Court said, all right, well, now, in certain cases, the Supreme Court then said, all right, well, through the 14th Amendment, the Fourth Amendment now applies to the states. All right, so it wasn't always to apply to the states from the very beginning of the Constitution. The 14th Amendment applied those eventually through the doctrine of incorporation. And here's the different times and the cases where the doctrine was applied to the states. So as you can see here, the first case applying freedom of speech to the states was in Gitlow in 1925, right? And so it's not, these are when the First Amendment, the Second Amendment eventually was incorporated just recently. And we'll get to that. And then here's the Fourth and Fifth Amendment. And as you can see, they were gradually adopted into the states, but not from the very beginning. Okay, so it took the 14th Amendment to apply the Bill of Rights to the states, because the Bill of Rights initially only applied to the federal government. The Second Amendment, the right to bear arms, was incorporated in the McDonald v. Chicago case, and so it applied the right to bear arms to states and municipalities. We talked about this before, the Establishment Clause. Congress shall make no law respecting the establishment of religion. And the Free Exercise Clause, government can't prohibit the free exercise of religion. Some religious practices may conflict with those rights and then be denied or punished. So, for instance, I gave the example before of sacrificing animals in violation of the health codes in a certain city. You're not allowed to sacrifice animals as part of religious ceremony in violation of the health codes, or holding poisonous snakes, or smoking different forms of illegal substances. And so the different areas of Establishment Clause. The Establishment Clause has been applied to education, no prayer in schools, religious activities in public schools, school prayer evolution, public displays on city and municipal property. We'll look at a few of those cases. Free Exercise Clause. You cannot violate the rights of others. For example, the Amish are pacifists, and so they had an exemption from being drafted into war because of their religious beliefs. You can't suffer discrimination in employment because of your religion. And if you have any kind of law that in any way hinders the free exercise of religion, it's under strict scrutiny. So that's the standard that the court uses. The Supreme Court, when they gauge whether or not that law is constitutional or not, has to have a compelling state interest that's narrowly tailored towards whatever they're trying to do with that law. And so part of the Lemon test, Lemon was a case that established a lot of the actual standard for the religious test. Okay, so which of the following is not a part of the Lemon test? Law must neither advance nor inhibit religion. Law must not foster government entanglement with religion. A law must not impose costs on religious organizations. A law must have a secular legislative purpose. So the only part of the Lemon test, or the only answer which is not part of the Lemon test, is that the law must not impose costs on religious organizations. The rest of this makes up the Lemon test that the Supreme Court uses when they are talking about religious cases. Okay, the law must neither advance nor inhibit religion. This is establishment law cases. Can't foster government entanglement with religion, and it has to have a secular legislative purpose. And here's the Lemon case, and this was aid to parochial schools, so financial support for private religious schools, and the question was each statute, in order to be applied, had to have a secular purpose, could not enhance or advance nor inhibit religion, and it can foster excessive entanglement with religion. Okay, so that was the test that came out of the Lemon case. In Zelman v. Harris, it was determined that school vouchers, that states would provide a voucher system where they would give you a voucher to go to whatever school you wanted to. And so in the Zelman case, vouchers were upheld as constitutional. So the Establishment Clause in regards to public schools, you have to provide equal access to all religious groups, no matter what religion. So if you open it to the Christian groups, it has to also be open to the Muslim groups, the Jewish groups, the Hindu groups, whatever religion that wants to use the facilities has to be in there. Can meet after school hours, allow all kinds of groups. No specific religious flyers can be in the school, and you can't give scholarships or instruction. School prayer can't allow any kind of specific mental coercion, so there can't be any forced school prayer or even a perception that a policy is in place to enhance school prayer. Public displays. So they can't advance religion, but you weigh that against a legitimate historical purpose. So kind of the public displays law is, if you're going to have them, then you have to have the cross, you have to have the Jewish menorah or the Star of David, you have to have a Muslim symbol. Basically, you're safer if you have every single religious symbol all in the same public square. Freedom of speech. So there's several aspects of freedom of speech. Prior restraint, and case citations, free speech in the public order, obscenity, libel, slander, symbolic speech, free speech and fair trials, commercial speech, and regulation of the public airways. So prior restraint is basically another word for censorship, right? The government censoring freedom of expression, and preventing some material from being coming on the internet or being published or what have you. It may be permissible in wartime, depending on the purpose for it. If there is sensitive information or something like that, if it's just generally criticizing the war, then that's not permissible. You may be punished after something is published. Um, so if you publish, for instance, like we've seen with WikiLeaks, the release of confidential information is subject to criminal sanctions and those kind of things. And so if Edward Snowden is caught, then he will be tried in the U.S. court system. Whoops. Neer versus Minnesota is one of the key cases in Supreme Court history on censorship. The government couldn't censor or prohibit a publication in advance, and so it doesn't apply to students. But you can prohibit something from being published that contains kind of a national security secret. And so the government generally cannot prevent or censor things from being published. And so here's a couple cases. So Schenck v. United States. During World War II, Schenck mailed circulars to draftees. The circulars do not submit to intimidation to be drafted, but only peaceful actions such as repealing the Conscription Act. And so then the test was a clear and present danger standard. And so Oliver Wendell Holmes developed this standard. The question is, in every case, is whether the words used are used in such a circumstances or of such a nature as to create a clear and present danger that they will bring about substantive evils that Congress has a right to prevent. So during wartime, utterance is tolerable and peacetime can be punished. And so the question was, when Schenck wrote all these circulars saying, don't submit to the draft, was that a violation that could be punished? Was it dangerous or merely inconvenient? And Schenck was prosecuted under that provision. Free speech is limited if it presents a clear and present danger. It's permissible to advocate the violent overthrow of government in the abstract, right? But not to incite anyone. So you can't lead the charge with the pitchforks and the axes towards the government. But in the abstract, you can talk generally about anarchy and stuff like that. And that's freedom of speech. But you can't create a clear and pleasant danger of inciting people to rebellion. You're limited if you don't have that as much freedom of expression if you're on private property. Right? So a shopping mall can ask you to leave, just like any private citizen can ask you to leave private property. Your freedom of speech does not extend as far on private property as it does on public property. So the other standard, imminent lawless violence. So Brandenburg v. Ohio Brandenburg was a leader in the Ku Klux Klan, and nobody liked this guy, right? He was going to try and do a Ku Klux Klan rally in Ohio, and the question was, the Ohio law tried to prohibit him from having his march. However, the court used a two-pronged test and said speech can be prohibited if it's directed at inciting or producing imminent lawless action, and it's likely to incite or produce such action. The act made illegal the advocacy and teaching of doctrines while ignoring whether or not that would actually incite lawless action. So the failure to make that distinction, the court upheld the guy's right to have the Ku Klux Klan rally. Right? No one likes to have that, but if it wasn't inciting immediate lawless action, then if the law was written too broadly, then that was an unconstitutional law in Ohio, and Brandenburg was found not guilty. Freedom of the press and fair trials. The public has a right to know what happens in government, but we have a new phenomenon with the WikiLeaks deal. Releases of confidential information through WikiLeaks and Bradley Manning. You have Edward Snowden and those leaks. The press's own information may not be protected. Obscenity. Now this is prurient stuff. So what constitutes improperly, overly sexual speech and things of that nature. There's not a clear definition of when something crosses the line, right? Generally, child pornography way past the line, and that's not, you don't have a freedom of speech to that. But short of that, in the pornography area, there's differing legal standards on what constitutes that. So Miller v. California set up that standard. And so if the work appeals to a prurient interest in sex, which means a really bad interest, or a particularly vile interest, that's patently offensive, and it lacks any kind of serious literary, artistic, political, or scientific value, then it's not protected speech, right? So it's obscene speech and it's not protected, and it can be regulated. A lot of local areas make their own decisions on this obscenity, so you see zoning that doesn't allow adult shops and things of that nature. It's hard to define obscenity. So in Rothbard, the United States, whether the average person applying contemporary community standards as a whole would say this is only appealing to the vile sexual interest. Well, again, what does that mean? Well, basically, what the Justice of the Supreme Court says, I don't know what obscene is. I only know it when I see it, right? So you can't really define it in words, but if you see it, you think you can describe that that's past the line and therefore is not protected. Violent video games. When can you start to regulate that as improper speech? Libel and slander. So libel is publication of items that defame somebody's character or reputation. Slander is spoken instead of written. So libel is written and slander is spoken. Again, there's different standards for amongst private individuals versus celebrities, and it's very difficult to prove. The standards are very high to prove that you had an intent to be malicious and it was untrue and all those kind of things. So libel and slander are very difficult to hold somebody liable for in a court. Defamation. So in public figures, you have to be intentionally malicious, right? There has to be an intentionally. You have to prove that the public figure, what you did towards a public figure was intentionally malicious to destroy their character. For private individuals, if it's false, if it's defamatory, meaning that it's hurting their character, and it's negligent, then you can hold private individuals liable for libel and slander. Symbolic speech. Oops. So symbolic speech, not all speech is written or spoken. It can also be nonverbal, like burning a flag or wearing an armband. Generally protected along the same lines as verbal speech. So you have the right to burn the flag as a symbolic speech. You have the right to donate money to a campaign as symbolic political speech. You can wear an armband. You can wear various things in support of political movements that you feel strongly about. So the armband case was upheld. You can burn the American flag. You can march in a parade. You can't burn draft cards, and you can't make threats. All right. So any kind of symbolic speech, if you can't threaten somebody with a Nazi flag or a Confederate flag or something like that, that won't be allowed. Commercial speech. So communication in the form of advertising. Generally, it's most restricted and regulated. It's got to be truthful. You can't falsely advertise, but it is protected speech, but it is highly regulated. And so you have a lot of TV that's censored, right? You can't say certain words on public TV that you can on cable. Even on cable, there are certain ratings that apply, and there's a rating system in place. And so a lot of cable TV has expanded the rules of what's allowed, but the over-the-air channels are still subject to the FCC rules that were in place for a long time. And one guy who's blurred a lot of those lines, Howard Stern, right, who moved from where he was to satellite radio partly to push the envelope where he was at. campaign contributions as speech. So in Buckley v. Vallejo, spending money to influence elections is protected speech, right? And so then we had the McCain-Feingold Act, which regulated how campaigns received money. However, a huge case then after that in 2010 was Citizens United, which basically overruled McCain-Feingold and said, nope, you can't have those kind of restrictions on political campaign contributions. So it's opened up the can for political action committees. You have a ton of action committees that are almost as powerful as parties now, right? So the parties they have some money, but a lot of the money and control are in political action committees now in elections, and Citizens United helped with all that. You have the freedom to assemble, so you have the right to get together with other people who feel like-minded. You can peacefully assemble in different places subject to local restrictions. So just because you have the right to assemble doesn't mean you can stay on a private lot that says no trespassing and claim the right to assemble, right? There's the local authorities and private individuals have the right to regulate time, place, and manner for places for you to stay in. And obviously, you have to balance freedom and order in society, right to associate with whoever you want. So you can be part of whatever group that you want without the government interfering and you being discriminated against for doing so. Everybody's favorite part, the defendant's rights. So in criminal justice, the Fourth Amendment is huge, right? Protection against searches and seizures, because if you get charged with a crime, one of the first things your defense attorney is going to try and do is suppress evidence as a violation of your as being an unlawful search or seizure or confession or something like that. And if the police fail to follow those rules, then it can get you off from being not guilty, right? So courts continue to rely on or continue to rule on what's constitutional and what's not as technology changes, right? Can we search your cell phone at any time, or do we need probable cause? All those kind of things come into place. And so here's the criminal justice system, right? So at every stage you have different constitutional protections. We'll just walk through those quick. So once the crime is committed, evidence is gathered, suspicion is cast, right? You have the protection at that stage. There has to be a warrant to search your, there has to be probable cause to search your car. You have to get a warrant to search other containers or your house. If you're arrested, you guarantee the writ of habeas corpus, meaning that you can't be imprisoned without evidence. Once you're arrested, you have the right to get your Miranda warnings. You have the right to counsel, and you have the right to be informed of what accusations were what you're charged with. When you're prosecuted, again, you have the right to counsel. You're protected with the Fifth Amendment. You don't have to testify on your behalf as a defendant. If you're imprisoned, you're protected from excessive bail under the Eighth Amendment. At trial, again, you have the right to counsel. You have the right to a speedy public trial with an impartial jury. You can't be tried twice for the same crime under double jeopardy. And like I said, you have the right to trial by jury unless you waive that, and you have the right to confront the witnesses against you. And then if you're found guilty, you have the right against cruel and unusual punishment. So the debate right now is kind of on capital punishment, whether they've stopped doing. The company that would make lethal injections has stopped making those, knowing that they've been used in death penalty situations. So now the states are trying to come up with other ways of doing the death penalty. And the questions are, is that cruel and unusual to do electrocution? All these things, firing squad, all these things are coming back as possibilities because lethal injection isn't in place anymore. And here's just a different look at the that same kind of chart, just a different way of showing the chart. So in searches and seizures, the police have to have probable cause. When police have reason to believe that the person should be arrested and was involved in a crime, right? If evidence is obtained in proper manner, meaning don't have probable cause to search your car when they stop you, then anything they find in that car later down the road is poisoned, and it's the tree of the poisonous fruit thing. If, let's say they find you, or they find guns and drugs, but they had no probable cause to search your car because you didn't give them permission, they can't prove they have probable cause to search it, then anything they find thereafter will be suppressed and won't be heard at trial. The exclusionary rule means that no matter how incriminating the evidence is, if it was obtained unconstitutionally, so if they find cocaine and illegal guns and all kinds of stuff in your car, but there was an unconstitutional search of your car, all of that is suppressed, and you don't get charged with any of that, or you don't get convicted of any of that. You have the right against self-incrimination, so you can't be asked to testify against yourself. You complete the Fifth Amendment. You can ask for a lawyer as soon as you're arrested. You're given the right to remain silent, the Miranda warnings that we see on every cop show. Entrapping a criminal into something. So there was a case where the cops tried to set up a sting operation where they kept sending people in to try and catch somebody in a crime, right? Well, if they catch them in a crime, but they kept trying to sell them drugs, kept trying to sell them illegal things over and over and over, was that the police entrapping someone to make a move like that, or is it something else, right? And that entrapments may be overturned. The Fifth Amendment, this is just a self-incrimination slide. Miranda rights, right? The right to remain silent. Knowledge that what you say can and will be used against you in a court of law. Right to an attorney. Right to have an attorney provided if you cannot afford one, right? So you want to always have that, ask for an attorney before the cops start questioning you. The right to counsel. There's the public defender's office, and they have good attorneys in the public defender's office that will be appointed for you if you can't afford one, right? And that's guaranteed under the Sixth Amendment. Trial by jury, almost 90% of cases settle now, even in criminal law, right? So even in criminal law, you come up with a plea bargain because you don't want to get socked with an even longer prison sentence or jail sentence. You'd rather take a deal, cut a deal, reduce your sentence, and hopefully get through it. Juries usually are composed of 12 people. Sometimes unanimity is not required, but in most cases, it's going to take all 12 jurors to convict you in a criminal case. Cruel and unusual punishment. And so again, there's a lot of debate. Nebraska just recently passed a law vetoing or ending criminal punishment, or the capital punishment in the state of Nebraska. The governor then vetoed the ban on capital punishment, and then the Nebraska legislature overrode that and reinstituted the ban on capital punishment. So Nebraska no longer has capital punishment. And a lot of the debates about cruel and unusual punishment are going to fall along the capital punishment route. Many cases that are capital cases stay in the system forever because there's lengthy appeals involved with a capital case, so that before anyone's actually executed, there are several opportunities to prove whether the system has gotten it right or not. Right to privacy. So again, the right to privacy is not explicitly stated in the Constitution. So first kind of discussed in Roe v. Wade and other cases, saying that, well, you have the Fourth Amendment, you have the Ninth Amendment, a lot of protection against quartering of troops. It's a lot of privacy, as we saw in the confirmation hearings of Roberts and Ford. A lot of privacy in the Constitution, even though it's not, explicitly state there's a right to privacy. The courts have found that there is a right to privacy, and therefore they've introduced that in through different cases that have been there. And so we see something like Roe v. Wade and cases thereafter that have dealt with that right to privacy. So in a democracy, people need civil liberties to express themselves, and courts figure out what those limits are. The pursuit of happiness extends so far, and you can express yourself up to a certain point, right? And you see courts struggling to define where that line is. And you have to decide the line, as it says there in the slide, between freedom and order. Where do the courts draw the line at how far you can express yourself? And so, do we try to have limited government in this way, or do we regulate it? And in which situations do we and don't we? Those are